Good morning, everyone, and welcome to Hull & Hull's first breakfast series for 2013. I'm Susanna Popovic-Montag, and I'm very pleased to welcome all of you who are joining us here in person, those of you joining by webcast, and those who've called in as well. Thank you for joining us. We will start with just introducing a couple of the members of our firm who are here so that we can put some names to faces. I'll just ask everyone if they could kindly raise their hand. We have Paul Trudell, Jonathan Cappy, Moira Vishoyu, Holly LaValliant, Suman Jaffrey, Stuart Clark, Natalia Angelini, Noah Weisberg, Alex Bishop, sorry Alex, I was having a seniors moment, Josh Eisen, Christine Mercer, and Heather McGuinness. I also want to thank the ladies out in the front who are helping us here today. We've got Sarah Koslicki, Diane Labau, and Heather Fritchkowski. We were very pleased to be able to present today on a couple of very interesting issues. We hope that you'll find them as interesting as we did in preparing for them. I'm joined here at the front with David Smith and Ian Hull. As part of our inaugural series of breakfast meetings this year, we're implementing some new technology today. And each of you who is attending here in person has been provided with a keypad. Now, for those who are participating by webcast, please ensure that you've had an opportunity to log into www.rwpoll.com and that you enter Hull and Hull, spell that out, Hulland, as the session ID. Now, in the spirit of keeping everything and everyone's responses completely anonymous when we pose our questions, because we really do want you to participate, when you're entering online through the rwpoll.com website, don't feel the need to fill in the name information. So once you've gone into the main screen, if you get to the welcome screen and after that, if you just click continue, you'll be able to enter into the polling without having to identify yourselves. So, with that under wraps, we're going to move on to our very first topic on trusts and trustees. And Ian's going to be addressing the topic, and our very first question for all of you who've got your clickers in hand and your fingers on buttons by webcast. What allows the court to distinguish a trust as being a sham as opposed to a fraudulent conveyance? Is it 1, that the trust is written in written form; 2, the trust in question is a discretionary trust; or 3, the key for the party attacking the validity of the trust is the settlor's control? So if you choose on your keypad your answer, lock that in, we'll be able to do our very first polling. Okay, I know there's more than 20 people who are out there, and I've only got 20 responses. Okay, I'm going to close polling. Alrighty. Wow, look at that. 85% of us have said that the key is for the party attacking the validity of the trust in the settlor's control. Over to you, Ian.
Well, 85% of us are very right, but as all legal questions, not dead right, to use the pun, the other elements of the question do tease out what is really the sorts of questions that the court wants to consider. And I just want to spend a few minutes on this topic, in large part because got all my technology. I've been trying to vote on it too. I got it wrong, so. In large part to address a recent decision that I think highlights what the trend is, where the trends are going in some of these trust and trustee questions in the context of validity of trust, and is the trust a valid trust? The case I'm going to talk about in a minute is the Duca decision. It's in our paper, but what I will talk about first, though, is just the general concepts. And what our question starts to outline us is, what do we have to look for? And the key to the party attacking the validity of the trust is the settlor's control. And what does that really mean? Well, if we look at first principles on sham trusts, and what is a trust that just is entirely a sham, we compare it to a bare trust. And obviously, when we're practicing, we're not out there drawing up sham trusts with a view to avoid the trust principles, but we will often run into situations where a bare trust is necessary. And it's just a simple trust, of course. It's a repository of the trust property. There are no active management duties to perform. And I guess the difference between that is the sham trust, on the face of it, is really looking like a trust. There's a trustee, there's a beneficiary, there's equitable rights that seem to be created, and the Duca decision really struggled with what those equitable rights were, and that equitable and beneficial ownership is intended to be remaining with the settlor. That's kind of a lot like a bare trust in the terms of the context of the presentation of it. But a sham trust really ties into being a pretend trust. And so what the Duca decision, I'm calling it Duca, Bozo, whatever, Bozo or whatever, Bozo probably after you've read it. The Duca decision does is it helped us tease out, the Court of the Court of Appeal looked at it in terms of the core element of what a validity of a trust is. And it was interesting because they looked at it and they said, is it a trust that has been created here? Is it a sham trust that was created here? Was it a fraudulent conveyance? And these situations do often arise in multifaceted corporate holdings, where we've got a person who has created a holdco, a company, so let's call it a family co. And in this case, in this decision, the husband and wife own 49 and 51% of this company that in turn bought a piece of raw land and went into development with that raw land with a bunch of other people. So they only owned a bit of the raw land, but this holdco up here was owned by the husband and wife. And of course, what happened was the raw land deal went bankrupt. The deal went sideways. A $1.2 million loan is owed to Duca, and Duca's looking around scrambling to collect. They have personal guarantees, and they have guarantees to the corporation up above here, and they go after both the husband and wife. And so the husband, who's starting to sniff the fact that no one's buying any houses on this property, proceeds to enter into a declaration of trust. Now, the timing of it is very important, but he enters into a declaration of trust. So up here, he wants to protect his wife because he knows the creditors are coming at them hard, and he wants to protect his wife from attack. So he says, guess what? I own 100% of this company up above. Notwithstanding the shareholding, say 49-51, I own it. I declare it. There's a declaration of trust that says I own it. So the creditors go up to go chase the wife, and they get the Heisman, as my kids call it, the straight arm, and say, you can't go after wife. Fine, take husband down and bury him in bankruptcy, but you can't take the wife down because the husband goes, I owned it all. You can't go after her. And so the court looks at it and goes, okay, what do we do? How do we deal with this situation where a declaration of trust is imposed in between this whole process? And interestingly, I mean, I guess it made sense. At the first level, it was, I think it was Justice Cunningham, he looked at it and he said, look, is it a sham? Is it a fraudulent conveyance? The creditors are all over the fraudulent conveyance side of it, but they weren't really all over the sham trust side of it, which was sort of fascinating. But the court said, look, it's a trust because the father intended to maintain control. So it's not a fraudulent conveyance, and it's a trust. And it's not a sham because of some other facts that don't really matter in this case, but that declaration was a valid declaration. The Court of Appeal says, nice try. What the distinction here, and they taught us, is that because the husband maintained control over the corporation before he made the declaration of trust and after, there was no intention to create a valid trust. So the declaration itself was in and of itself, either they don't really care, they didn't describe it this way, but it was a sham or it was a fraudulent conveyance. It was an attempt to change control when control had already been changed. And so the husband, who was truthfully running this holdco 100% and wasn't really listening, wasn't taking any direction from the wife before the declaration was made, the court said, did it change at all? And one of the questions they pull right out of the decision is the creditor's counsel says to the husband, before the trust was created, made the declaration, and after, did anything change? And the answer was no. So the Court of Appeal jumped on that, and they said that's the whole element of where we're going to start to really drill down on what is a valid trust and whether or not a valid trust was created when he declared it as the full ownership. And the key was how much control and when. So we come back to this in a lot of estate planning scenarios, and we run into this trouble a lot in the sense that we want to create these multiple structures and multiple wills to bring that into, but any time we set up any sort of branching of corporations, the courts are going to say, well, we're going to want to know what was happening before in that corporation if you're going to then impose a trust over any of those holdings after. And this decision is pretty seminal in some respects because it stopped this trend toward chasing these things, as I think in large part as a fraudulent conveyance, and they sort of said we're going to keep it in the trust world and stay out of the Fraudulent Conveyances Act. But the truth is that it was a fraudulent misrepresentation. I mean, that was where the bank sort of dropped the ball. If they had pleaded it a little differently, this decision would have gone very differently, probably. But it wasn't pleaded that way. They went after it on the basis either it's an invalid trust or it's a fraudulent conveyance. And although the Court of Appeal overturned the lower court and found that it was not a valid trust and therefore the wife was exposed to the creditors, it did it in a way that was, I think, a bit backwards in some respects. But that's the beauty of case law. There's always facts that will turn the thing upside down. But the lesson for me was is to make sure that we understand that when we do have a situation where the husband is actually or the wife is fully controlling the corporation and we want to somehow impose a new trust obligation with that asset, we have to be very careful because the control is going to be looked at both before and after, and the validity of the trust is going to be questioned in that way. So the next question we have, Susanna.
What rule of the rules of professional conduct needs to be considered when drafting a discretionary trust? Is it Rule 2.02 sub 1, when advising clients, a lawyer shall be honest and candid? 2.026 sub 1, before providing legal services under a limited scope retainer, a lawyer shall advise the client honestly and candidly about the nature, extent, and scope of the services that the lawyer can provide, and, where appropriate, whether the services can be provided within the financial means of the client, or 3, both of the above.
So as we're all answering this pressing question that we all woke up this morning asking ourselves, you'll have to forgive us, but for us to achieve our goal of making sure that you get 0.5 of that special hour that we all have to chase down for the Law Society, we have interwoven into the rules of professional conduct questions and practice management questions to meet the auditing standards of the Law Society. But we'll wait for the answers to come out and then just briefly comment on this.
Great. So I'll give you a couple more seconds, and then I'm going to close polling. Okay, here we go.
How's our totals? It does math as fast as I do. Houston, we have a problem. This is the first time we've tried this, as you can see. It's
Back. Technical difficulties. There we go.
All right.
All right. Well, thank you. So 91% of people thought that both of those rules applied.
And I think that just the comment here is this. This takes us to the next, in this topic of trusts and trustees, which we're going to wind up because we want to cover a variety of topics today, is that when we're asked to draft our trusts, there is obviously the paramount issue is, of course, the drafting and the work that we have to do to make sure that we've properly drafted it and that we're not taking instructions to create a blatantly sham trust, as may have been alleged in the Duco case. But more importantly is that when we're asked to, in many situations, drafting these discretionary trusts, the question of candor is vital, and of course and the question of our abilities to draw these trusts within the scope of our day-to-day practice. the twists and turns can get complicated. We've got ODSP trusts, we've got Henson trusts, and we've got fully discretionary trusts, all of which have creative drafting elements to it. And so I guess to, again, completely satisfy our audit requirements here, we have suggested all of those above will be will be welcomed when we are questioned by the Law Society when we drew that trust.
Thanks very much, Ian. So moving then to the next topic of taxation of trusts and estates. Historically, we know that there have been very few audits of both inter vivos trusts and estates, and I think that's primarily because there's been this lack of resources to both monitor and enforce the requirements. So seldom have we ever seen probate fees actually being assessed. Now, however, with CRA's new compliance initiative and the implementation of the domestic trust audit program, which is going to hopefully enhance compliance, the expectation is that we'll see an increase in the number of CRA tax audits and probably of probate tax as well. And so what this probably will mean to us is that auditors are going to be delving into not only how a trust is set up, but also how it's maintained. Are the trust tax returns being filed on time? Are the other provisions of the Income Tax Act being applied? Also, the Ministry of Revenue is given powers now to audit probate applications and the values that are ascribed to the assets by the estate trustee or personal representative. And if they find infractions, then we can expect that there's going to be a reassessment of trusts and possibly even of the beneficiaries for the income tax or the interest or the penalties or the probate fees that ought to have been paid. Now, how many of you have heard of this position at Canada Revenue Agency known as the Ontario Region Trust and Estate Coordinator? Have you heard of that position? Press 1 for yes or 2 for no. Getting our responses in pretty quickly. I'm going to just close the polling now. And we find that 97% of us haven't heard of this, and I got to say I'm not surprised because it is a relatively new change that has come about in the legislation. What the Trust and Estate Coordinator for the Ontario region is, their role is to actually organize and then prioritize some estate and trust related tax issues and to develop the technical support and the training and to provide it for the CRA's compliance department and staff in Ontario. So it's part of this, initiative that CRA is implementing so that it can try to increase the compliance that is being done by people. How about the idea of a related party initiative? Have you heard of this concept with CRA, the related party initiative? I've closed polling by accident. I'm going back. Awesome, thank you. So while we're just waiting for everyone to get in their votes, what the related party initiative is, or what its goal is to focus on high net worth individuals and families who have net assets of at least 50 million and who have 30 or more related economic entities associated with them. And what that means are people who have within their family organizations trusts or corporations or joint ventures, partnerships, those kinds of structures. Not many of my clients are necessarily going to fall within this framework of individuals, but certainly CRAs out there looking for it. So if we look at what we see in terms of the audience, this time a few lesser people have heard of this. 86% have not heard of related party initiatives, but as part of our hope that we can bring to light issues that are timely and of importance to practitioners in certain senses, we'd like to raise these two concepts with you. So clearly we've got Big Brother watching us on a higher level than maybe even we had before. So how do these kinds of changes translate into our practices on a daily basis? Well, I think from an ethical or from a practice management perspective, whenever we're dealing with these kinds of issues, or we're dealing with, our normal practice will include the probate fees, the payment of the estate administration tax. What we'll want to do is to make sure that as we're taking our information from our clients and we're filling out these applications with them, that we are meeting the standard of competence, that we know of changes in the legislation that somehow are going to affect our practices and our clients, to make sure that we're meeting the quality of service that's expected of us. And so I expect that because of the increased ability or expectation that we'll see audits of the probate fees, that a lot more greater attention is going to be paid to the applications, that the values that are ascribed to assets will have probably valuations or appraisals attached to that, because there is going to be this increased looking at values. Personal representatives are going to be exposed to possibly being reassessed, and there are consequences to that. There's also going to be consequences to us as their advisors in the event that we're somehow found to have facilitated an improper value being ascribed to assets for the purposes of probate.
And just on that point, John McCauley and I were just chatting before, and an interesting problem, of course, is we've got CRA now ramping up, as IRS are ramping up in the U.S., because this is low-hanging fruit. This is where as the wealth passes down, the taxing authorities are starting to sort of build up around it. But in Ontario, of course, we've got them building up because we're going to be in a situation, we keep saying soon, but Ministry of Revenue, of course, we don't have a government in Ontario operating right now, so I guess we can't blame them. But we, Ministry of Revenue is going to be stepping in to audit our probate tax as well. And from that perspective anyway, it seems to me that it's the advisor's exposure is starting to get created on things like a joint account scenario, where we've got a joint account, a client comes in and says, I want to set up this joint account. And if we as advisors aren't making sure that we're covering all of our bases with our response to those instructions, we too, not necessarily going to get dragged into the audit, but we're going to maybe get turned around on and said, well, look, now you told me that this joint account idea was a good idea. I'm now being told by Minister of Revenue that this is really not a joint account, and then it's an estate asset, and then I owe tax on that estate asset. I paid all the money and spent all the time to create this fancy scheme, and now I'm going to look to the advisor for not having given me the heads up that this could go badly. So as opposed to the old days, I guess, when we were more comforted by the fact that there was really no meaningful audit in Ontario, those days are coming to a close end, and no doubt if we're not on top of that, as advisors, we're going to get looked to. So thanks, John, and thinking that through. Sorry, I'll let you continue.
Thank you. So then we'll move on to our next topic of powers of attorney. And David is posing some questions to the group, starting with, if you hold a power of attorney and you don't act on it, do you have a duty to account? And to those who are calling in, the choices are 1, yes you do, 2, no you don't, or 3, maybe. Covered all our bases.
And I think the purpose of starting this section with, before David steps in on these questions, is that this is one element of the case law that David's going to make a comment on, but one element of our practice as advisors, again, when we have created the document, what are we saying to our client, both verbally and in writing, when the power of attorney is created, and what are we saying to the attorneys if they're our clients, if there's a finding of incapacity? So as the numbers roll in, are we almost tallied?
I'm going to close the polling.
We'll let David address this.
Yeah.
So this is good. I like that answer.
Yeah. This, you know, as litigators, when we run into situations, maybe is always a preferred choice, because in our world, the reality is that there's different fact situations and different judges looking at the circumstances, and the answer is not always black and white, and can sometimes be fact specific. The reason that the answer is maybe is that, you know, historically, certainly since Justice Cullity gave his decision in Banton quite some time ago, we've always had this sort of mindset which, when you're an attorney acting where the grantor is capable, then you're acting as an agent, not as a fiduciary per se, and so the obligation is to account to the grantor, but not necessarily to account to anyone else if the grantor is comfortable with what you're doing. Conversely, if the grantor is incapable, then there's a real onerous obligation. The difficulty in this situation is that there is a decision out there, and we'll post it on our website, but there's one decision, and it's in the minority for sure, which seems to say that if a grantor makes a power of attorney, and if you don't act under it as attorney, are you accountable? And the case seemed to suggest that, well, yeah, there is a duty to account. It still comes back to the question of who are you accountable to? Because, again, if the grantor is capable, then the situation should be one where you're accountable to the grantor and not to the world at large. Where this gets complicated, and it's highlighted in the Koperniak case, which is in our material, is after the grantor has passed away, you may have a situation where the beneficiaries of the estate are making inquiry into what happened during the lifetime. And even if the medical evidence suggests that they don't have a goodwill challenge, there's beneficiaries out there who will say, well, you know, that's fine, I accept I don't have a will challenge, but you know what? I get 1/5 of this estate under a will, and I think you took money over the last year of Dad's life. And if the medical evidence said that Dad is capable, you get into really, from my point of view, if I'm acting for the executor trying to defend his or her actions, my inclination is to say, well, hold on a second. I was accountable to Dad during his lifetime. The medical evidence says that he's capable. So there's really no issue here. But again, there's a case out there which seems to suggest that there may be a sort of inherent duty to account to beneficiaries, and it all hinges on this issue of what happens after death. Because the key witness in these cases, of course, is the grantor. And the grantor is not there to give evidence and say what was intended. And so the court's left in something of a dilemma. Now, of course, most of these cases settle, but having a case out there which raises some question about this causes us, when we're advising clients, to say, well, you know what, there's no certainty as to how a judge is going to view this, because the distinction between agent and fiduciary and whether or not the grantor is capable seems intuitively the right way to go on this, but it's not always that simple. Ian, maybe you just...
Yeah, I just add to that, one last thought on this was, from my standpoint, is it's as an advisor, from my standpoint, I'm always telling my clients that once you take on the fiduciary role, you have no idea what you've just stepped into. And this is a perfect example. I think it's Seth. We'll get the decision. I forget it. But the Fair and Campbell is it's a divisional court decision which basically said if they're capable and you're not acting on the power of attorney, you don't have to account. Tarek used to, which was the Court of Appeal, used to be the leading case on this until everyone started ignoring the Court of Appeal in the area of estates. But that basically said you got to act on it. You got to sign something. You got to do something before you're expected to account. The difficulty is that when we have these outlier decisions that are sort of floating around, it just keeps reminding me to say to my clients, you know, do you really want this job?
Yeah.
Do you really want to give this job to so-and-so who may not be the world's greatest, most responsible person?
Right. I think those are excellent points, Ian. And I just thought what I could do is just refer briefly to this Koperniak case that we referred to in our materials and segue a little bit into the whole issue of who can compel an accounting, and touching on what I just mentioned about the capacity being a key issue. In the Koperniak case, you had a really interesting situation, which was a contested, what appeared to be a hearing. I'm not sure if there's viva voce evidence, but the court considered an awful lot of evidence as to whether or not a daughter of a grantor of a power of attorney had a right to compel an accounting in circumstances where the grantor was capable. And again, this highlights what we just were saying. Intuitively, you'd think, well, no, if the grantor is alive and capable and authorizes what's being done, then it's not for a disgruntled sibling to go to court and compel an accounting. And under Section 42 of the SDA, there's this very broad clause which allows anybody to go to court and say to a judge, you know what, I think something bad's going on here, I want an inquiry to be made. But in Koperniak, the court looked at capacity and said, you know what, and what's surprising about the case is the court went into a fairly detailed analysis about who got gifts, who acted on checking accounts, who did what kind of activity. But at the end of the day, the court said, you know what, this lady was capable. She was doing what she wanted to do, and I'm not going to sit here, judging whether or not these actions were appropriate. And so in that case, it all hinged on capacity. The neat thing there, and I think the thing that we need to advise our clients as well, is Section 42.4 of the SDA is the section, and it's very broad. It literally says any person with leave of the court can go to a judge with an application, doesn't have to have any relationship whatsoever, just needs to raise some issues to a judge saying, I think you need to compel an accounting here. But it seems subject to all the vagaries that there are that Ian touched on, and the uncertainty which leads us to say maybe to what looks like a fairly straightforward question. It looks like capacity is a pretty key issue, but as we all know, capacity is not always black and white. And so I think the whole inquiry here and the discussion really lends itself to some important dialogue with the client in terms of what needs to be done. I think also that leads us to your next question, Suzanne.
Yes. The rules of professional conduct in part define a competent lawyer as a lawyer who has and applies relevant skills, attributes, and values in a manner appropriate to each matter undertaken on behalf of the client, including knowing general legal principles and procedures and the substantive law and procedure for the areas of law in which the lawyer practices. Is that true or false?
So as we're answering this pressing question, again, if you think a CRA audit is tough, wait till the Law Society audit comes in to check if this was really a half hour of ethics. But it's sort of a fun question to throw out there, but it does highlight the fact that a simple question to a client is, of course, what's my duty and what are my obligations if the power of attorney gets created, and what is the donee's obligations and duties, and we need to know that there's mixed case law in this example, and we need to know that we have a duty to warn our client that this possibility of non-activity accounting still exists in that sense, and that taking on this job of fiduciary is no easy feat. So I'm pretty sure that the answers will roll in with some pattern as soon as we see the answers, but that's in large part the reason why we wanted to ask that question. May as well close it. It's not how did the numbers come in?
The numbers came in at 97% said true.
Awesome. And the false is actually right too, because we only took part of the rule. But that wasn't a trick question. All right.
So moving along then to Joint Family Ventures post-Kerr.
So we just want to throw some questions in on this one because we worked hard on trying to highlight this JFV concept. Now, Kerr was the decision of choice, I guess it came out a year and a half ago, but certainly this isn't a year in review. It didn't come out last year, it came out the year before. But now we're starting to see some fallout for it. But what I certainly have seen and what I'm forced to remind myself is that what is this concept of JFV or JVF or whatever it is? What's the short form? JFV. Because even yesterday I was on a case with Susanna. We worked all day on a mediation, and the JFV concept didn't come up once. And as I was preparing this morning, I thought to myself it probably should have. So it shows you how hard it is to keep these new trends in top of mind. I don't think JFV has actually revolutionized the world, except in the family law world they got very excited about it. But in the estates world, I think it's sort of just dovetailed a bunch of the same concepts of proprietary estoppel and things that we'd already been talking about. But let's talk about Kerr first. And the first question is, have you heard of this decision? And only because I just said it, you might have. And I'm going to answer yes. But let's work our feedback through only because it starts the juices flowing on what is Kerr and what is Kerr's sort of implications. And we can probably close the polling on that one pretty quickly. Good.
Wow.
So this is important. I mean, I just think the illustration's there. We live and breathe this stuff, and we didn't really throw that word around yesterday when we might have, because it is actually relevant to these cases. And the next question is, what kind of cases is it relevant to? The Kerr decision sets out a framework for the application of principles of equity to property claims by unmarried spouses. Is that true or false? And as we all go to press our buttons and open our polls, the answer is long shot that it's a false. And what's important here really is developing this concept of JFV, and so our numbers came in pretty strong there. The next question, have you heard of the concept of JFV? Let's just sort of get an, I mean, first of all, how many clients have heard of, I mean, how many people have heard about the Kerr decision, but how about JFV, or this concept of joint family ventures?
We're making you work quick on this one, aren't we?
All right, so the last couple of questions I want to ask on Kerr are going to be after we talk a little bit about Kerr and the feedback. So let's see what our totals are on this one. Good. So again, putting this concept, joint family ventures, JFV, top of mind can't hurt, because it is a Supreme Court of Canada decision to Kerr, and it did get all these professors and family law lawyers very excited, and it has a big impact in the estates world too. This is the concept of trying to deal with unmarried spouses in a more sophisticated way. The results tend to, as I say, mirror what we've been doing already in the estates area, but it's just another wing and another consideration. So how do we get a better handle on what Kerr said and what it means is, in my view, any time a Supreme Court of Canada decision comes out, I sort of like to read the other cases after it, because they're much smarter than I am, and I don't really understand what they're saying at the Supreme Court of Canada level. So I go to the Hillier decision, which is in our paper. In that case, it's a couple from Newfoundland. And they built a house together. Now, what that means and how they did it is, of course, factual based. The wife apparently did some interior decorating. The husband was a carpenter, and how much they did and how much they didn't do is, of course, part of the big battle. But the interesting thing here was it was an on and off relationship. All right. She had come from a very modest circumstance. She was on social assistance. She had a child. There was, as I say, spicy on and off stories about the nature of the relationship, but they finally separated. They did an agreement. She got a little bit of dough, and then, lo and behold, Mr. died 3 months later. So she moves back into the house. It was empty, so why not? And so the estate's a little grumpy and wants to kick her out. That's the nature of the trial. That was the nature of the proceedings and the steps that were taken. And at the first instance, the trial judge was asked to decide whether JFV was established here. Was this a joint family venture? And therefore, was this spouse, this unmarried spouse who had moved back in, entitled to more than even what was under the separation agreement? So the trial judge struggled with a bunch of the facts and came down to, and I think in large part because it was pretty spicy how much they would be together and then they would be not together and why, and all the sorts of throwing plates and things like that. So the judge said, look, I found a joint family venture, and I'll go into why he found it in a minute, but he said I'm going to limit it to the duration of the cohabitation, not to the relationship. So it was fine-tuning it, because these cases, they fight over how much I did, and then they fight over what you did it for, and then they fight over how long you were together as well. So in this case, it's just a great illustration, because the court said, look, they didn't really care that she wasn't around all the time. The attendances at the house didn't make a big deal to them. That was a factor only being put forward by the estate. What they needed for this joint family venture was to look at the way their activities, financial activities, and their conduct was. And in this case, there was one bank account in Mr.'s name that they worked out of. She was on social assistance, and that seemed to matter to the judge because she was now in a house and not on social assistance. Contribution, of course, and the detriment to the contribution is fundamental to the allocation and how they'd go it. Together, they were viewed as a couple that got together to bring a family together, but at the same time they had both agreed that they were going to build a house together to live in together. So that concept was very important to the court when trying to apply this JFV, in that the intention of the parties was to build a house together to live in. And the building together wasn't as important as the comma to live in. So the court made a decision that she was entitled to more than just a separation agreement. In fact, this claim for a joint family venture claim, and that it was established sufficiently. She got 10% of the equity in the house. She wanted 50% of the equity in the house. And interestingly, the court, again, these joint family venture cases are going to be moving like on the facts, but in this case they said we're only going to talk about the growth or the efforts that were undertaken with regard to the house. Now, in Kerr, it was different, and where we're going to see more often is that the joint family venture on all of the assets. But in this case, the court said, no way. Look, this was just these facts cannot embrace the rest of his assets. We are only going to lump you into this house, what you did for the house, because, again, the court was very focused on what was the intention of the parties after this combined effort was. And they were very fixated on the point that the intention of the parties was to live in the house together as a family. So, if you want to go after all the wealth, the court said you got to find a better link. You have to find contributions to the whole wealth. So if there was a cottage here and a RSP or a long-term relationship, all of those things make sense. And again, at the end of the day, I'm not sure that the JFV really turned the world upside down in the estate's context, except that it's starting to gel this concept that we keep hitting a wall. If you're not married spouses, the courts will not, and the legislature has not set in the rights of a married spouse on death, as we know. So we have to look to other remedies. We look to the Part 5 of the Succession Law Reform Act. That's an obvious remedy for unmarried spouses. Now this concept of joint family venture is another layer of calculating how much a non-married spouse is going to be able to pull out of an estate on death. And the considerations are run through by Kerr and certainly are run through in this Hillier decision, because and why it kind of rose to the attention for this year was because the facts were it was a very tangential relationship in some ways. I mean, there really was lots of times she wasn't there. There was times she was there. There was really tough facts on just how much she accomplished in terms of the contribution. And that's, I think, helpful for us to determine when we have a client who comes in and they are in a non-married scenario, that alerting them to the fact that this joint family venture option is available. So the last couple of questions I've sort of led with the answers on, so let's see if anyone was listening.
We'll have our quiz now. Does a joint family venture offer more flexible remedies to unmarried spouses? Yes or no?
We're going to make these questions tougher next time. This is our first try.
So 91% of the audience said yes. Now, once established, should a joint family venture's duration be limited to 1, the duration of the cohabitation, or 2, the duration of the relationship?
And this wasn't really well written by me, I apologize, because I think that the answer is 3. Both. But in the Hillier case, they only looked at the duration of the cohabitation because of the spicy facts. So you listened, but I gave you the wrong answer. Because the duration of the relationship is a factor. It's always a factor in these unmarried spouses. If you've got a 20-year relationship, families have to get over it. It's a real marriage, and courts are going to treat it as a real marriage in many respects. So the duration of the relationship is a factor that is need to add a third answer to that.
Our next question, does a joint family venture allow for a claim to all the wealth amassed during the relationship? 1, yes. 2, no.
Again, not well written. Depends on the facts. So as we answer this, I think it's just so important to tie in all of these relevant factors of the duration of the relationship and what's going on with this couple, because if it's a classic common law spouse relationship, the courts are going to look at more than just the house, as they did in this case. In the Hillier decision, though, it gives us an illustration of where and how you can separate this joint family venture argument to one asset. And this is exactly the way proprietary estoppel cases have been going for many, many years in the UK, and that is that if you can identify the promise and the detriment, so this is the same in joint family ventures, this is really just proprietary estoppel, but if you can identify the promise and the detriment to a specific asset, for example, in this case it was the house, but if, for example, if you're looking after a nice old lady and you're a gardener in one of the cases in the UK, and that old lady says, nice older lady who says, look, if you do this for me for the next, till I die, you can have the, and it was, in this case, it was not a shed, but it was sort of a bunkhouse. You can have the bunkhouse. Now, she had other assets, and the court said, no, she made it clear. You made a deal. Your work was going to be for the bunkhouse. You don't get to go after the amassed wealth of her other assets. And in the Hilliard case, it's the same thing. The judge was able to identify a particular asset on the facts. But does that mean that it's always going to be the case? Of course not. So, again, I don't know why, as a litigator, I wouldn't have had maybe there, but I must have been doing this too late last night. So our answer is good. This is good. So it's mixed because it should be. The last question. At least I wrote this one right.
And that is, can a joint family venture claim be limited to specific property only? 1, yes, 2, no. And the answer is...
So as we're, yes. Beautiful. So everybody at least is knowing how to press the buttons quick. So next time we'll have fancy pictures and maybe jokes halfway through them. But that's my comments on joint family ventures, which is now top of mind for me and hopefully top of mind for you a little more, because it is a relevant consideration. And like anything, once the Supreme Court of Canada coins a term as joint family venture, it matters, and we should be using it with some vim and vigor, because it's really is out there, and although it describes everything we're already doing in some respects, it's always nice to mimic the Supreme Court of Canada.
Thanks very much, Ian. So turning then to passing of accounts. David?
Thanks, Susanna. So we'll leave the questions to the end and leave you in some suspense on this section. The passing of accounts part of the talk, we've got a case we referred to in our material. I'm going to touch on that in a minute. This topic is a natural partner, if you will, to what I was speaking about earlier, in the sense that it's always important for us to remember that the duties of an attorney for property or a guardian for property are, remarkably similar to those of an executor, so much so, I mean, we know about fiduciary duty, but we also have a formal requirement imposed on guardians for property and attorneys for property, and that formal requirement is to have a duty to account, to be ready, willing, and able to account, but it's more than that. It goes to the format of the accounting, and certainly I think in all of our practices, this is one of the most difficult things to convey to clients. The number of times that I've certainly, and I'm sure many of you in the room, have had to deal with clients' resistance to estate format accounting. It's one of these things that's very troubling. Quite often clients will go to their accountants and their accountants have not heard of it or are not familiar with it. And we have to explain to clients why it is a necessity, regardless of the size of the estate or regardless of the property that's been administered and is subject to a duty to account. And the case that we have in our material, the Reed-Dam estate case, is one of a litany of Justice David Brown's legacy to the estate bar, which is there's many cases, we're familiar with them, where he really went into very minute issues that people really hadn't turned their minds to, and set out in black and white what the obligation was. And he was always quite often inclined to insert a bit of opinion as to whether it was an appropriate state of affairs. And in the Dam estate, you had a very small estate, you had a duty to account, you had a fiduciary who shows up with a set of accounts, not in estate format. Reading between the lines, the judge seems to be saying, you know what, this probably in a certain situation would be a satisfactory fulfillment, excuse me, of your duty to account. But unfortunately, I'm stuck with Rule 74 point 16 and 17, which has the form of the accounting and imposes an obligation on attorneys and guardians to account in exactly the same fashion as an executor would have to. And this ties into our previous case that we talked about. If somebody compels an accounting and the judge says, yeah, you've got a duty to account, and I'm going to compel you to account, then you've got to do those accounts in a state format. And again, it's one thing that I think the cautionary tale here is there's been a number of instances where lawyers who are not familiar with the state format accounting nonetheless prepare the accounts for their clients, try to pass the accounts, and if there's a minor involved, the Office of the Children's Lawyer will just be ruthless in terms of a claim for fees. And regardless whether you make a claim for increased costs or not, no judge and certainly no children's lawyer representative or PGT representative is going to in any way be sensitive to a learning curve being paid for on estate accounting. And I mean, that sounds a bit harsh, but I mean, I think it's just a cautionary tale that we all need to be aware of, because the courts are very careful to scrutinize the legal fees that are incurred. And so we've got this tough situation where clients probably have great difficulty sometimes understanding why estate format accounting needs to be in that format. And I think the Dam estate is an important case for us to alert clients to, because, and sometimes I think it's useful to give the case to the client. This is a great case in the sense that it's short, simple, it's not a lot of legalese. Justice Brown's language in his case is very straightforward. I think it's a good situation where if a client says, why do I have to account, give them a copy of the case and say, look, for what it's worth, the judge in this case threw it out there that if the legislature and courts want to consider a different set of accounting principles for smaller estates, that's something for the legislature to do, but not something, and sorry, I think I said the courts, but it would be something for the legislature or the Rules Committee to do. But as a judge of the Superior Court of Justice, he said, I'm bound to this set of principles with accounting. Now, if all parties have counsel, I think we're all familiar with circumstances where you can settle a case without a state format accounting. But if push comes to shove and you're forced to go to court, we're stuck with this owner's duty, and it is what it is. I think this might be a good time to touch on our questions, Susanna.
Given the likelihood of a variety of competing financial interests in many passings of accounts, what rules of professional conduct apply? 1, Rule 2.04, avoidance of conflicts of interest, or 2, Rule 2.04, sub 14, unrepresented persons.
Again, there should be a 3 here. This one I didn't write. No, it's this is again one of the struggles that we have with passive accounts is what David was saying, is the format, as well as the fact that we have to touch on all financial interests. And so in coming to that, we often do face the difficulty of unrepresented persons in the pool of individuals, and sometimes they end up being involved in the passive accounts or not. So we just have to be very sensitive to that, and secondly, very sensitive to the conflict of interest, because we might act for an attorney in various capacities, in their personal capacity and then in their capacity as attorney, and again, that can raise problems. So I guess the answer to this is 2 for sure. 3 is worth considering if we're into that scenario, and sorry, 2 is definitely worth considering, and 3 is probably both if in the right circumstances. So, go on.
I was just going to introduce our next question. When a lawyer is dealing on a client's behalf with an unrepresented person, the lawyer shall, 1, urge the unrepresented person to obtain independent legal representation, 2, take care to see that the unrepresented person is not proceeding under the impression that his or her interests will be protected by the lawyer, 3, make clear to the unrepresented person that the lawyer is acting exclusively in the interests of the client, and accordingly his or her comments may be partisan, or 4, all of the above.
So again, this is just a worthwhile reread of a rule that we always intuitively know, but the expectations of the Law Society in these scenarios are pretty naturally achieved, but worth rereading for the purposes of this type of passive account scenario. So the other thing we're finding too is that the judges, although there's new rules with regard to getting increased costs orders over the counter, the judges are throwing them out, not really realizing that the new rule exists, and so we're sending them up and we're not supposed to attend, and then they get thrown out because we haven't attended. So we're having some struggles with the new rules and keeping the new judges up to speed. But that's all well and good, and there's a perfect answer. What a perfect group. We just want to touch on, oh, sorry, Suzanne, you transition to the next.
Go ahead, Ian.
No, that's fine, you go ahead. You're on the next topic now.
Yes, the dependent relief claims. I know many of us are familiar with the whole concept that a dependent, a spouse, a parent, a child, a sibling, who is found to be a dependent is going to be entitled to support from a deceased if they haven't made adequate provision for the proper support of that individual. And we look to Part 5 of the Succession Law Reform Act for that. Now, previously, as practitioners, we knew that this test was going to be applied based on a needs basis, and so it was a financial need kind of analysis. But as a result of the 2003 decision of the Ontario Court of Appeal in Cummings versus Cummings Estate, we now are also looking to some moral and ethical claims as well. And so what we're really seeing in practice then is this balancing of this whole concept of testamentary freedom, the right to do anything you want with your own estate, with testamentary obligations, both legal now and moral. And when we consider these claims, one of the things that I certainly keep in mind when I'm meeting with my clients is this limitation period of 6 months that applies when you're trying to consider bringing these claims. Under Section 61 sub 1 of the SLRA, if you're going to bring an application for support, you've got to do so within 6 months from the grant of probate. Now, if it turns out that you're past that 6 months, there is an extension provision in the legislation. Section 61 sub 2 allows the court to exercise its discretion and extend the time for the initiation of a proceeding if it considers it proper. And so the whole question in the cases when we're looking at whether or not a judge is going to exercise their discretion is it a proper situation in which to do so? In our materials, we address some of the cases that look at extensions or requests for extensions and when judges are prepared to grant them and when they're not. I think really one of the better summaries that you can find is in the Blatchford decision, where the court there says, you know what, it's not automatic. So even if there is assets that are left that are undistributed past 6 months from the grant of probate, you won't automatically be able to bring your claim for support. What the courts are going to look at is a consideration of all of the factors of the delay involved. What was the nature of the delay? What were the reasons for it? And what is the extent of prejudice that the estate is going to face in having to defend the claim now that it's past that time period? So what is proper is really going to depend upon the facts of each case, as it many times does when we're dealing with the exercise of discretion. I'm just sort of looking towards our time. We're coming pretty close to the end of our presentation. So what I might do is maybe just throw out our last question to the audience. And that is, if you're meeting with the spouse of a deceased testator, who's also the estate trustee, do you need to send her away for independent legal advice? And the reason I put this question to you is that because many times when we're dealing with these situations and meeting with widows or widowers, we've got a client who'll come in, they'll have a will, the will will appoint them as the estate trustee, and they're seeking advice and our help in terms of that role that they have as the estate trustee. But also circling in our minds are these possible FLA claims for equalization, possible dependence relief claims, or other entitlements that these individuals might have on the basis of constructive trust or resulting trust. And so the question is, when you're meeting with an estate trustee, do you have an obligation to tell them of all these other possible claims that they might have, or is the obligation to them in their role as an estate trustee and in the best interests of the beneficiaries? So if we just take a quick look at what we hear, 52% of us think that there's no need to send clients out for independent legal advice. And that's, you know, I expected it to be closer to 50-50 because of the fact that even as practitioners, those of us who practice in the area, we all have our own different ways of dealing with it. And I think, we try to be as efficient as possible, and when we're meeting with someone, we want to make sure that they know and are apprised of all their rights. But as part of giving that advice as solicitors, we are struggling with things like conflicts of interest. Are we acting perhaps to the detriment of beneficiaries of an estate by telling them that the trustee has other rights that might ultimately, if they were to pursue a Family Law Act equalization, for instance, might reduce the amount that's ultimately available to them? So these kinds of considerations are always circling in our minds when we're looking at who is our client, what is our duty to them, and what is our duty to document at the end of the day what it is that we've told them and how we provided our advice. Just open up to any other comments from Ian or David as we move into the end of the formal part of our presentation. We've run out of a little bit of time on Will Challenges, but we're happy to address any questions anyone might have. We can now turn to the question and answer session. So if there are people who have specific questions that they'd like to raise to us, we ask that they please come up to the mics and put those to us.
And it's 9:30, so don't feel that you have to. We want to make sure everyone knows that you can sneak out as we get into the question period. We've run a little bit over time because of the number of topics we tried to grab, so don't feel as though you have to stay to the bitter end here. But John.
Ian, I'm a little confused about joint family venture and constructive and resulting trusts. They seem to be at least very similar, if not identical. And in terms of drafting pleadings, would you differentiate them in your pleadings? And just help me with the distinction between the two concepts.
Yeah, I think my personal view is it's really hard to distinguish it from that and from prior to estoppel. All the same sort of factors are being out there. I think I am now I'm imposing it into my dependence relief applications as a sort of a phraseology to give a court more comfort with the term. I've certainly personally tried for years to get people to understand what proprietary estoppel is when I'm in front of judges, and they glaze over and ignore it. So the resulting trust stuff and the constructive trust stuff got all sort of sexy when PCORI came down, and so we could say that was the way to do it then. Now we're saying joint family venture. I do think the Kerr decision is more important in the family law bar than it is on the estates because we were already there. They were struggling still during lifetime unmarried couples and how to manage the split of the assets, and certainly after separation. But I'm not sure it makes a heck of a lot of difference. I just now am throwing it in because I think it's I don't think you can be precluded from making that claim once you've raised the other trust claims anyway. But I just throw it in because now it's a fancy name, and it makes me think people think I know what I'm doing.
In arriving at the value of an estate, can you get a clearance from the minister?
In Ontario, no. They've said that they're not going to give a clearance certificate yet. Now, they may change, but that's their initial pressing on that question. The initial was no, they have no intention of getting into clearance certificates. So that's another nice little problem that we're faced with. Thanks, Sid.
That together with the fact that we still don't know what the form is going to be and what the filing period is. So as Ian says, I think as practitioners we're going to go through a little bit of growing pains to see if it's going to cause delays also in the distribution of estates, because people are going to be extremely cautious because there is no clearance-like mechanism. Do we have any other questions?
Sorry, but just one more, Ian,
Sure.
to the group. In terms of the new Estate Administration Tax Act, there are going to be two filings, am I correct? One with the Estates Court and one with the minister.
That's right.
Subject to audit. Okay.
Well, thank you very much for joining us. That brings us to the end of this breakfast. Our next one will be on June 13th. If any of you have any topics or any suggestions for things you'd like to hear from us, please feel free to drop me an email, and we'd be happy to address those. Thanks very much, everyone.